A tragic crash on California's Pacific Coast Highway. 4 young college girls killed, a 22-year-old behind the wheel. Was it a horrific accident or murder? The shocking courtroom battle is about to unfold, and the defense has a controversial plan that could change everything. Stay tuned.
A California 22-year-old back in court, accused of murdering 4 girls with an alleged speeding BMW on the Pacific Coast Highway.
It was tragic. It was emotional. It's devastating. But it wasn't murder.
The man who is now defending him is a familiar face. The same attorney who defended Karen Reed, Alan Jackson. And this week he tried to get the 4 murder charges that his client is facing dropped. And he even referenced an infamous murderer who killed 4 people.
These are the same charges that Brian Koberger is facing.
What Alan Jackson says his client was actually running from when his car hit 4 girls who were about to graduate college. We're on the case presented by Law and Crime. I'm Chris Stewart. What's the difference between it being an accident and a murder? That's the question that's at the center of this case that we're following out of California, where 4 girls were allegedly killed by a man who was driving a BMW gifted to him by his parents. That man is Frazier Bohm. Now, he is in court this week in Southern California. He is facing 4 counts of murder for what happened along the Pacific Coast Highway on October 17th, 2023. This specifically took place in an area called Dead Man's Curve. Now, Bohm's new high-powered and likely very expensive attorney for his family argued in court that the murder charges that his client is facing should be dropped, and that what we're talking about was really nothing more than an accident and a tragedy. Here's why. Police say the then 20-year-old Bohm was behind the wheel of his BMW. It was gifted to him by his parents for his 16th birthday. All of this took place in Malibu, a very ritzy, wealthy part of Southern California. And Bohm was allegedly going 104 miles per hour. The speed limit in that area, 45. Now, Bohm was reportedly speeding along the Pacific Coast Highway. It's a very scenic, but can be very dangerous stretch of road. Most of the pictures we could find of the PCH is after the wildfires that hit Malibu, but you get the idea of the kind of road that we're talking about here. On that night in 2023, Frazier Bohm was allegedly going more than twice the speed limit, and these 4 girls were getting out of a car on the shoulder of the PCH. Their names, 20-year-old Neam Rolston, 21-year-old Peyton Stewart, 21-year-old Asia Weir, and 21-year-old Deslyn Williams. The 4 girls were sorority sisters at Pepperdine University. They were seniors, and in the spring, they were going to graduate and continue on with their lives. Now, police say Bohm hit them with his car, and all 4 girls were dead. Now, the area of the highway where Bohm hit those girls, it's known as Dead Man's Curve. And according to KABC, the stretch has the most auto accidents of any other part of the 21-mile highway. Bohm was arrested a week after the crash. Prosecutors say the deaths of these 4 girls, they weren't an accident. In fact, they are calling these deaths murders. Prosecutors say that Bohm accelerated from 93 miles per hour to 104 miles per hour just 2.5 seconds before hitting the first 3 girls, according to data that was retrieved from the BMW and the so-called black box in the car. Now, they argue that the acceleration is proof that Bohm was driving in a way where this crash was not an accident, it was an act of murder. Now, Bohm's attorney, Alan Jackson, in court this week argued that those murder charges should be dropped, saying that speed cannot be treated as malice.
What act did Frazier Bohm commit that objectively involved a high probability that it would result in death? That's the question before the court. That was the question before the magistrate. What happened on Pacific Coast Highway, I could not be clearer about this, was a tragic collision. But tragedy does not equal murder. And the law does not permit the district attorney to convert a fatal accident into second-degree murder simply by calling speed malice. Because we go back to that first postulate, speed cannot be malice in California. Your Honor, there was no alcohol, no drugs, no texting, no racing, no distraction, no prior DUI by my client, no advisements, no Watson warnings, no statement of indifference after the fact, no criminal history, no driving history, no bad driving history. Those serious consequences imposed by the government in a judicial proceeding. Nothing that has ever been cited in the cases where implied malice has been upheld in California. So what are the people left with? What are they left with? All of those no's, one after another, after another, after another, Judge, all of those no's make them rely on one thing, and one thing only, and this is the basis of their entire theoretical postulate. Speed. That's it. Alleged speed at that. Disputed speed.
Jackson's questioning if Boehm knew that he was actually going as fast as the prosecution claims that he was, but the judge pushed back on that in court, questioning how Boehm could not know that he was going much faster than the speed limit.
The problem with the prosecution's case and the magistrate's holding order is that there's no evidence. The record is completely deplete of evidence that Frazier knew how fast he was going. That's why I brought up his statement.
How would somebody driving 100 miles an hour or 90 or whatever the speed actually was up in that range not know that you're going super fast? How would you not know that? Realistically.
Super fast is not the standard.
No. But answer my question. If you're driving a car 95 miles an hour, you know you're not driving 40. Am I wrong about that?
You're not wrong about that. But speed alone is not.
I understand that.
Speed alone is not. It's not enough.
But to gauge a person's knowledge of what it is that they're doing, the consciousness of it, you have to use common sense as well. And I'm sorry, when you're driving 95 miles an hour, 100 miles an hour, you know you're driving extremely fast. You know that.
If other cars are driving 70, 75, 80 on Pacific Coast Highway, which, Your Honor, they do all the time. I mean, now we're just talking about perception, right? Now we're talking about the court's perception. You must perceive that you're going fast. I was on that road 2 weeks ago. There were sports cars passing me. I was going 70. By the way, that was above the speed limit. Didn't realize it because every car next to me was either going the same speed or going faster than me. It's a perception issue. It's not like he was going 70 or 80 or 90 miles an hour, or whatever the speed is, which the prosecution cannot find in a 25 mile an hour zone right next to a school. He's on PCH. And other cars are going similar speeds. Yes, he may have been going faster than the cars next to him,
Yes.
but not to a degree that it's a near certainty to cause death.
Well,
And that's the point at which it would have to be.
I'm going to discuss the testimony of the prelim and what the underlying facts of the case are, but just as a preview, all of the evidence from the civilian witnesses in the case is that the defendant zoomed away far faster. They couldn't even come close to saying with him he was driving so fast.
Sure.
He was hundreds of yards ahead at the time of the crash.
The witnesses, not a single witness at the preliminary hearing put him going 100 miles an hour. Not a single one. As a matter of fact, the witnesses that were asked how fast do you think he was going, they estimated him going around 70.
Now, why Boehm was allegedly going so fast is also at the center of this case. Prosecutors say there's a man named Victor Calandra who noticed that Boehm was driving fast prior to the crash, and he allegedly told Boehm to actually slow down at a red light before the 22-year-old sped away and crashed a short time later. According to the Pepperdine Graphic newspaper, Calandra said when he and Boehm ended up next to each other at a stoplight, he saw Boehm had his cell phone between his legs, under the steering wheel, and was possibly texting. He then allegedly told Boehm, quote, "Hey, you need to be careful, you're going to hurt yourself." He says the light then turned green and Boehm gunned it. Seconds later, Boehm allegedly hit those 4 girls, taking their lives. Now, Boehm's defense says any communication with Calandra was actually a confrontation, and Boehm was scared, so he was fleeing a road rage situation before the crash. That's why he was going fast.
Here, there's not even evidence that Frazier intended to drive fast for its own sake. Every available piece of evidence supports the opposite, that he was reacting to events unfolding in the moment, including being chased, being clipped by another vehicle seconds before impact, That is not malice.
Now, at this hearing, Boehm's defense requested to be able to get data from Calandra's phone, the witness, including GPS data for location and speed, and they also want to see what communication Calandra had with other witnesses on scene. Now, Boehm also allegedly told investigators after hitting the 4 girls that it was an accident. He said that he had to swerve because he was trying to avoid a car that was next to him that had hit his driver's side mirror. Prosecutors argued that they found that car and it didn't have any damage. Now, here's what the prosecution said in support of those murder charges.
So the question now that we're facing is whether there was sufficient evidence presented to the committing court in order for there to be the order holding to answer. And the defense has said time and time again that speed alone is not sufficient. And speed in isolation is not the determination. Watson and all of its progeny, again and again, they don't provide any definition of what implied malice is. They talk about the circumstances and how every case must be evaluated on its own circumstances. There is no number that's ever provided by the court. This isn't a case of speed in isolation where the defendant was driving down an open road with no other vehicles, with no other cars, pedestrians, just flying and reaching high speeds. This is a case where the crime took place on a stretch of road that has homes on both sides, with driveways and garages leading directly onto the street, with other vehicles that were going the speed limit at the time that he was driving, cars parallel parking on the side of the streets, and pedestrians walking on those sides, given that that stretch of PCH, which the defendant said that he was familiar with, doesn't have sidewalks. This was all information known to the defendant at the time that he decided to engage in the behavior that he did.
Then, as Jackson made his final point, he made a very notable reference to a quadruple murder.
These are the same charges that Brian Koberger is facing. That's the point. Brian Koberger broke into a dorm and slaughtered 4 people. He's facing 4 counts of murder, a plea deal. 4 counts of murder. It's murder, Judge. That's the point. That's what the magistrate misunderstood. Is it dangerous? Sure. Is there a possibility that someone could have gotten hurt? They did get hurt, so clearly there's a possibility. Was there a high degree, a near certainty, as the Moore case put it? Was there a near certainty, a high probability that someone would die that night at that time, and that he knew it and disregarded it? The answer is no. It's resoundingly no. We don't have to like it. I'm not asking anybody to like what happened or to justify what happened. I'm asking the court, call it what it is. We are objective purveyors of the law. That's what we do for a living. We don't use emotion. We don't supplant tragedy for the law. We don't supplant emotion for the law. It was tragic. It was emotional. It's devastating. But it wasn't murder.
The judge then made his decision on whether Frazier Boehm should be facing charges of murder in this case.
Mr. Boehm was driving at the very least 70, maybe it was 80 or 85, and the objective evidence says it was 100 in a 45-mile-per-hour zone. He was observed to be driving erratically, moving from lane to lane, causing another driver to at least attempt to warn him to slow down before he hurt someone or himself. Several other drivers also noticed his very, very fast driving. One of them, I believe, honking at him. While Mr. Boehm did not run a red light, he did commit very, very serious traffic violations here by speed alone. I don't believe there was any evidence in this case that he applied his brakes either, not in terms of skids or that type of observable evidence of braking. And here, by his own admission, he knew how dangerous this was. His 2 friends, his best friends, were killed by driving at an excessive speed, extremely excessive speed, and he's very familiar with the PCH. And again, it's only reasonable to assume that due to that familiarity, he knows that the dangerous road is, in particular, the area called the Dead Man's Curve, where this accident occurred. The magistrate, Judge Edwards' findings that the elements of second-degree murder were satisfied for purposes of the preliminary hearing were well within the realm of the reasonable. The standard is not at prelim beyond a reasonable doubt. That's for trial. I'm not saying what the evidence will look like. If the case does go to trial, whether the case will be proven, whether the murder case will be proven beyond a reasonable doubt, or whether it won't, nobody knows the answer to that. But that's not a question for today. The question for today is whether there was sufficient evidence for the magistrate to make the findings that he did, including the inferences that he made, the law that he applied, and I do believe that the magistrate's findings were well supported by the facts as they apply to the law that's applicable in this case. So the motion is respectfully denied.
Join us now to talk more about this from California is former federal prosecutor and president of West Coast Trial Lawyers, Nima Rahmani. It's always great to have you on Law and Crime. Such a sad case here with these four girls who lose their lives. What do you make of the driver, Frazier Baum, facing murder charges for what allegedly happened on the Pacific Coast Highway?
Chris, thanks for having me. And it is a big difference under California law. Those second-degree murder charges, they carry a potential sentence of 15 years to life in state prison, where if the defense were successful, either before trial, which they weren't, or at trial and getting the murder counts dismissed, gross vehicular manslaughter carries a potential 10-year maximum sentence. So very big difference between the two charges here, and I'm not surprised Alan Jackson and the defense really tried to get those murder charges knocked out.
Yeah, and we'll talk about Alan Jackson in just a moment, because people who may have forgotten, it's hard to forget, but the Karen Reed trial, this is the same guy who's now trying to help another client in a case involving an alleged death with a vehicle. How in California law, can you charge someone with like vehicular homicide, or is there like another like more vehicle-based murder charge? How would that compare to what this client is facing here?
Under California law, you can be charged with vehicular homicide. It's actually a wobbler, which means it can be a misdemeanor or a felony. Let's say, you roll a stop sign, maybe it's a misdemeanor, you're texting and driving. Obviously, if you're under the influence of drugs or alcohol, it's going to be a felony. And, the sentence, like I said, can be a maximum of 10 years, depending on some of the more serious vehicular manslaughter counts. Usually we have 3 sentencing ranges here, so it'll be a 2, 4, or 6 range, so you might end up in the middle of that range if you're driving under the influence and you kill someone, for instance, and there's no other aggravating factors like a previous DUI, fleeing the scene of an accident. Obviously, it depends on the prosecution. I mean, here, you're talking about something pretty significant, racing, going more than 100 miles an hour, according to the prosecution, which, of course, at this stage of the case, the judge needs to consider all the evidence in the light most favorable to the prosecution. Bauman's going 104 miles an hour in a 45-mile-an-hour zone, Dead Man's Curve here on PCH or Pacific Coast Highway. I've lived and worked in LA most of my life and probably driven that stretch of highway more than 100 times, and definitely shouldn't be going anywhere near 100 miles an hour on that curve.
How critical will it be for the defense? They're trying to argue that there was some sort of road rage incident involving their client and another man. That man said he had just told Frazier to slow down. But they're arguing, the defense, that Frazier was actually scared, and that's why he was going so fast. What will go into making a successful defense of this client, especially that part of it?
Well, the defense is going to have to come up with something. I expect there to be a battle of the experts. Their experts are going to testify that Frazier Baum was traveling significantly less than 100 miles an hour, maybe 50, 60 miles an hour, 70, but certainly not 100. So expect that. We saw that battle of the experts related to vehicles in the Karen Reed case, so expect that. But also some sort of argument, right? And again, I keep coming back to Karen Reed, where they had the argument that her boyfriend was killed by police officers in the home. But if you're going to be a good defense attorney, and Alan Jackson is one of the best, he's very well respected here in Los Angeles. Obviously, he did an outstanding job for Karen Reed, essentially not guilty, really guilty only on the most minor counts. You want to present the jurors with an alternate theory of the case. And I'm not saying that this is going to carry the day, but that's what good defense lawyers do. And they're going to have to come up with something, right? And this is really the only plausible argument that they have if Baum was really traveling this fast. Again, I'm not saying that he's not guilty or even not guilty of murder, but expect that argument at trial in this case, especially because Baum is facing so much time in prison. The defense may as well roll the dice here.
And when you bring in Alan Jackson, and I think for everyone who followed the Karen Reed trial, I mean, that alternate theory, and he just seemed very tenacious, and it was just each and every time, like creating this different, it felt like he was creating like a different reality for the jury. Now, if you believe Karen Reed's innocent, like that is the reality of what happened. But how would you characterize just his, as someone in the game yourself, how would you characterize Alan Jackson's style and how it could play out in this case?
Alan is very good, and they always say the best defense is a good offense. What he did to Michael Proctor in terms of discovering those damaging text messages, I mean, he destroyed a law enforcement witness like I really haven't seen, maybe since Mark Furman in the OJ case. I mean, that's how bad he was. And he really put the Commonwealth on trial. And the state made all sorts of mistakes, both in terms of the investigation and the prosecution. So it was botched. But, watching that case multiple times, right? Obviously, there was a trial and the retrial. It seemed like the state was on trial. Again, I don't think he's going to be able to do that here. You have 4 young victims, a really tragic case. I don't think Baum is any Karen Reed. But if you'd asked me years ago, there's a case where, someone, intentionally or unintentionally ran over their boyfriend, and their boyfriend was a police officer, and you'd have people outside protesting on behalf of the criminal defendant. I would have said that you're crazy. But so what Jackson did both inside and outside the courtroom from a PR perspective was nothing short of extraordinary. Again, different facts here, very sympathetic victims. I don't know if that's going to carry the day, but I don't think the defense is going to go down without a fight.
I find it fascinating, too, for this witness, Victor Calandra, who the story goes that he sees Frazier Baum and in his mind was driving erratically and pretty much was like, hey, man, slow down. And then Frazier speeds through, and then shortly later on the PCH, he hits these 4 Pepperdine students. This guy was living a regular life and probably in his mind was doing, if all of what he's saying is true, was the right thing, and just telling someone who is speeding, we've all seen those drivers before, and you're just like, gosh, can't that person just slow down? And if that's what was going on, I mean, what is he in for, especially with Alan Jackson? You think of Michael Proctor and how he went at him for this guy who potentially from his side of the story was just trying to tell somebody to slow down. What could he be in for if this thing goes to trial?
Yeah, I think the case will go to trial, and expect to see and hear a very grueling cross-examination. He's going to be one of the key witnesses in the case. And it can cut both ways. Obviously, we've talked about the defense argument, right, that this was some road rage incident and Baum was trying to get away. But from the prosecution perspective, he can be a great witness because he establishes Baum's knowledge and intent, right? One thing the judge mentioned during the hearing on the 995, where he denied the motion to dismiss, Judge Robinson here in LA said that, look, Frazier Baum knew that speeding was dangerous. He had a couple friends die in a speeding-related car accident. He told law enforcement that. And if you have a percipient witness telling him, hey, you're going too fast, this is dangerous, you're going to kill someone, something to that effect. I don't know if that's what the witness said, but that's very helpful for the prosecution because that establishes that mens rea, that criminal intent, that state of mind that's necessary for malice murder. Because, we've talked about it before, but murder requires an intent to kill, an intent to inflict serious bodily injury, or a depraved indifference to human life. And if someone's telling Baum that what you're doing is dangerous and deadly, and he does it anyway, that's enough for malice murder.
When it comes to the location of where this took place, Dead Man's Curve on the Pacific Coast Highway, beautiful, beautiful stretch of road there on the West Coast, but is it more for the help to the prosecution or the defense? Because on one hand, you have an area where there have been a lot of fatal crashes, thus the name Dead Man's Curve. On the other end, it's a road, if you've ever been on it, and he's from Malibu, so he should know. I mean, it's one of the last places you would think someone should be going 104 miles per hour. How could just the location play into the arguments we would hear in court?
Well, it cuts both ways. Obviously, I'm pro-prosecution, so I think it helps the prosecution hear someone that is from the area, familiar with the area, and should have known better than to drive that fast, in a 45-mile-an-hour zone, much less that particular stretch of PCH, Pacific Coast Highway. From the defense perspective, I'm sure they're going to spin it and say, look, this is something that was inherently dangerous, right? And look, some of the victims' families have apparently, pursued civil cases against Caltrans here for a dangerous condition that the stretch of highway was by itself dangerous, so anyone could have been involved in an accident. And that's what the defense is arguing here. This is tragic, but this was an accident. It shouldn't be a criminal case. Car accidents happen all the time. So expect to have them use that evidence and try to spin it to their advantage.
Since Alan Jackson has come on this case, which was only recently in the last couple of months, I mean, it was pretty quick after the Karen Reed verdict that he ends up taking on Frazier Baum as a client. He tried to get his bond lowered. That was unsuccessful. He tried to get the murder charges in this case dismissed. That's unsuccessful. What is the strategy that he's going for here, just kind of raising issues in court ahead of even getting to the point of a trial?
Well, Chris, there's two ways that he can play this. He can sort of swing for the fences and try to get a not guilty, right? Say, look, this was an accident. This was at most simple negligence, which isn't enough for gross negligence required by gross vehicular manslaughter. It wasn't criminally reckless. So that would be one, right? In which case his client walks. Or you could take a more cautious approach and try to knock out the murder charges and say, listen, this was not malicious. This was not intentional. This wasn't someone that was playing Russian roulette with people's lives. That's really what you think about when you think of depraved heart murder. And expect him to argue under, Watson. There's this famous California Supreme Court case that says, listen, this was just speeding in an accident. So even if you find my client reckless or negligent, it's just manslaughter. It's not murder here. And take a little bit more of a nuanced approach, maybe a safer approach. Get the client sometime in state prison, but not swing for the fences where the jurors might convict you of murder and put you away for quite some time.
I also look at Frazier Baum just as a client, and he's someone who kind of fits that stereotype of a rich kid, has a car bought for him by his parents. It was a BMW, lives in Malibu, expensive, zip code, and certainly the jurors are going to be from that part of the country as well. So it's not as if he's in a more rough neighborhood with jurors, but at the same time, how could just the profile and the stereotype of here's a rich kid who didn't care about the law blasting through 4 college students, could that come into play in just how the jury perceives him when he walks in the door?
No question, Chris. Perception matters. And if the jurors think this is some spoiled rich kid, some punk, driving daddy's car, not paying attention, that is potentially disastrous for the defense. So you see defendants all the time. It can be Sean Diddy Combs to Luigi Mangione, dressed in these subtle tones, certainly no fancy watches, shoes, or belts, right? They're going to make him look like an everyman, right? Just like an ordinary Joe, because that's not the impression that Jackson and the defense team is going to want to portray when they have their client in the courtroom.
And knowing that they've hired Alan Jackson right off, literally fresh off the Karen Reed verdict, and with this case, the experts that would need to be called in for a successful defense, is there a ballpark of just how expensive this type of defense would be? Clearly, if your life is on the line and years, I get it, in terms of the family if they have resources, but can you just speak to the type of price tag that comes with someone like Alan Jackson coming in and all the resources that would go into a defense like this?
Oh, all in, Chris, someone like Alan Jackson, again, he's one of the best, but I assume his rates are going to be steep, and trial is not cheap. This is going to be a 7-figure trial. That means millions of dollars potentially when it's all said and done. Prep, trial, appeal, all in. It's going to be very expensive for Frazier Baum and his family.
And then if this, if and when this goes to trial, and I know even from the prosecution side, like how confident would you be as a prosecutor going, you're going up against Alan Jackson. There's, definitely going up against one of the best, but just with the evidence that we know about at this point, the charges that they're going for, how confident would you be as a prosecutor stepping into the courtroom in this one?
Chris, I feel it's a strong case, assuming the prosecution can show that he was going 104 miles an hour at the top speed, 93 miles an hour, I believe, when the airbags deployed, lost control, killed four young college kids. I think it's a strong case. And let me tell you what's telling again. I've been in Los Angeles a very long time. Our former district attorney who got voted out of office, George Gascon, he was pretty universally viewed as being soft on crime, and that's why he lost his job. Even he charged this case as a murder case. That's how strong he thought the evidence was. And he was certainly not a tough as nails prosecutor. So I think it's a strong case. I think it's a good case. I think the prosecution will prevail, but never count someone like Alan Jackson out.
No, and